At the end of the day, it boils down to this. The homeowner has rights under 5200, and it forces an HOA to be transparent. And those rights or those documents that they're entitled to, they fit certain categories. And so the homeowner has the absolute right to these under the code. And the board has a certain amount of time to respond.
Yeah.
And again, that response time is a reasonableness standard. What is reasonable, right?
Yeah.
And there's different sort of classifications of that. And then to the extent that they don't respond and they stonewall you or sandbag you or however you want to frame it, there's penalties to that.
Yeah.
And those penalties can be very severe depending on how broad your request was. I'm Luke Carlson, and for almost 2 decades, my law firm, Ellis Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hi, Luke Carlson of Ellis Carlson Law. Welcome back to the show, Bad HOA. My host, Marty, welcome.
Hey, thanks for having me.
Thanks for being here as always. And today is a very exciting episode because we are now post Reddit launch of Bad HOA.
Yeah, the response has been tremendous.
It's exciting.
I'm really excited about it. So many of you people out there have really taken to it, which has been awesome. People are, there's a lot of comments in there. There just seems to be a need for people. We've got, as we talked about before, we have the HOA ones that are out there, but it's really just complaining and people trying to just get their voice heard. And I understand that. There's a need to just get it out there and be frustrated and have other people like hear you.
Well, I think there's room to vent online and on Reddit.
Yeah.
And you're 100% right. I empathize. I get it. You're living a nightmare. You want to get it out. You want to say, hey, has anyone else dealt with this horrible situation? And as we discussed, we wanted to differentiate, though. We wanted to say, yes, you can vent, but come up with some solutions. Let's be strategic. Let's actually use methodologies to go after these bad HOAs.
Yeah.
So we wanted to create sort of a different platform altogether.
Yeah, and let's be clear. I mean, I think the whole purpose of this was to try to give homeowners not just a place where they can vent, but also we want other homeowners that have solved their issues. We want that to be a hub for other people as well.
Right. A huge database compiled where you can go and say, hey, you know what? I want to see the issue that someone else has dealt with. And instead of ranting and raving and saying this is a dumpster fire and this person's a lunatic. Yeah. These are now situations where they say, hey, you know what? I tried this and it worked. Or, I tried this and it didn't work. And here's why. Yeah,
that is, I think, a huge gap that I'm hoping that this thing solves. And a lot of people seem to be taking to it. And we have a ton of stuff planned for this.
Let's talk about that because, ultimately, as I see it, the platform is really, our job on the platform is to provide additional resources, educational tools, and empowerment strategies, if you will, where homeowners can use if it's relevant to them.
Yeah.
Right. And so that's where we're going to compile sort of a database of homeowner empowerment content.
Yeah.
And then from there, it's up to the community to come together and say, hey, I love this. This works. This doesn't work.
Yeah.
And now it becomes this sort of evolving situation on Reddit, which I think is wonderful.
I'm really excited about it. And like I said, we have so much planned for it. If, there's only so much time in the day, but there's a lot of stuff that we have planned for it and a lot of content that's going to be coming down. That's going to be really useful for the end user when it's all said and done. This episode today, though, is taken right from our sub.
Yep.
So I want to be clear, we asked people, what do they want to hear about? And we had a lot of people ask the same question.
Yeah, we saw a trend. We definitely saw a trend there.
And this is what it's all about. This is what this thing is for. We want to hear from you. We wanted a forum where people could say, I need answers. And a lot of people voice the same concern. This very episode came from them saying, we want to hear about this. And so hopefully we're going to scratch them where they itch for this
Yeah.
one.
Well, it's a hot topic. It always has been.
Yeah.
And, our discussion of what we're going to discuss is California centric, but it could still provide a framework or allow other people to start thinking about this issue and look at their local state law, consult with their own attorneys if they're out of state, because, you're beginning to see individuals from all over the U.S.
Yeah.
And so if we could at least provide sort of some thoughts, some ideas of an approach, even though it's California centric, I think that's a win. And ironically, one of the funny things is about the podcast and about the subreddit is the empowerment in a way where we're trying to get, homeowners to sort of go after bad HOAs and hopefully not even use a lawyer.
Yeah.
So these are tools that, they can deploy. The one we're going to talk about today, 100%, you don't need a lawyer to do this.
Yeah.
Now, granted, I mean, when we get involved in cases, this is one of the weapons we use.
Yeah.
It's legal, it's permitted, it is a byproduct of really a homeowner empowerment piece of legislation, but they got to know how to use it, and it can be very powerful if used correctly.
Yeah.
So let's get right into it.
Yeah.
The topic is transparency.
Yeah. Transparency on what the HOA has to disclose or provide the homeowners upon request, how to request it, all the fun stuff. And I'm sure much to the chagrin of many viewers, what they can't.
Right.
There are areas that are sensitive that a homeowner doesn't have rights to. But this is an exciting topic, and what makes me most excited about it is that it came directly from the people. They wanted to hear this, and this is exactly what I hope. This is a reinforcement loop of we are watching, we are in there, we try to help curate, and we listen, and hopefully this is a helpful episode for them.
Agreed. So let's jump into it.
Yeah.
Let's start with just transparency. What are we talking about? And I can already see the comments under this. It's like HOA, what transparency? That's a major problem with a lot of bad HOAs, right?
Yeah.
It's like there's no transparency.
Yeah.
So 5200 is a legal right homeowners have.
What is 5200?
Oh, good question. I went too fast.
I know.
Civil Code 5200.
And that's a California Civil Code?
California Civil Code 5200. It's if you Google it, you can pull it up. But it essentially says, hey, you're a homeowner, you're empowered to request these documents from an HOA.
They're required to provide them.
Correct.
Okay.
And there's penalties if they don't, and there's this framework, right? And so what I wanted to do today was discuss 5200, how do you access it, how to think about it, and how to maybe strategically use it when there's a lack of transparency with one of these bad HOAs.
Yeah, makes sense.
So let's start. Maybe what are we going to cover? What we can request.
Let's start there. Yeah, let's go through.
Okay.
We have a lot of bullet points throughout this whole thing. So bear with us as we work our way through. It wasn't for sure. It's definitely not in my head on command here. So let's just work our way through.
It's a pretty robust statute, and I think for better. Ultimately, I mean, it gives you a lot of access points to documents that are mission critical when you're dealing with problems with your HOA.
Yeah.
So first one is sort of obvious, but it's financials. And that's such a hot topic, and it's such a major issue with HOAs, especially when an association is not providing financials.
Yeah. Can we get the sub points in there? Let's talk about financials. Like what type of financials can we request?
Yeah, so you're looking at budgets, reserve studies, projections, receipts, invoices, ledgers, and financials could also be executed contracts. Right. So what is the association contracted for, and how does that impact its P&Ls or its books?
Yeah.
Right.
So in other words, if there's a contract on a fence repair or the landscape or the property management, the homeowner has the right to review those records and request those records.
Correct. And that would be a 5200 request.
Yeah.
Right. And so you have this big financial sort of category, and I think that is a very powerful tool. But you also have access to governing documents.
Of course,
right?
Yeah.
Which is sort of obvious, and people say, well, that's sort of obvious. But the problem that we've seen is when you first move into a homeowner association or an HOA, you'll get HOA governing documents, CC&Rs, bylaws. But over time, those become antiquated. They become outdated. And you get into a situation where sometimes what you have in your cupboard or wherever you keep them, that's not the most current operating or most current iteration
Yes.
of the governing documents. And so this allows you to go to your association and say, hey, give me the most current CC&Rs, most current iteration, or bylaws or whatever it is.
Yeah.
Because what we've seen before is, some of these associations will actually amend, revise, and not notify all the homeowners, which is a problem unto itself.
Yeah. Well, I think we talked about that a little bit. Like that there's look at the other episode. Maybe we'll link it for them.
Yeah. And so this allows you to say, give me the most current up-to-date version of the governing document.
Yeah. You've got V5 and you want V9.
Exactly.
Yeah.
All right. So next one, board and membership meeting materials. So, what is that? That's minutes, that's agendas. That is, you got notices, anything from these meetings, right? That is public. You have the right to demand or request it.
Yeah. Just putting it on a button before I just wanted to make sure that we covered the bullet points. So on the last one was CC&Rs, bylaws, rules, enforcement policies, election procedures.
Yes.
So I think the two obvious ones were the CC&R and bylaws, but any other rules and election procedures, I think that the nitty gritty there, I think, is really important because so many things happen with like election enforcement procedures. That is all
one way of looking at it is, what are the rules of the game?
Yeah.
Give me all the rules and all the sub rules and all the rules that you guys secretly came up with behind everyone's back.
Yeah.
We want everything.
Yeah. All right. Sorry, not to
No, of course.
Okay. Continue.
So board and membership meeting materials. So what is that? Meetings or minutes, agendas, notices. What else we have? Membership mailers. Oh, that's a big one. Yeah. Membership mailers, essentially, you have these meetings taking place, and the spirit of Davis Stirling, the spirit of these HOAs is that they should be transparent. They should be open to the public. But let's say you didn't make one or you missed one. The idea is homeowners should have access to what happened at that meeting. And this allows you to get access to that if they don't give it to you right away. Sure. And that's a good distinction I should make too. On the one hand, you could go to the board and say, hey, could you give me the most current version of this, of the CC&Rs or the governing documents, or give me the financials? Yeah. A good HOA will just turn it over. Yeah. You see the distinction there? Yeah, absolutely. It doesn't necessarily have to come to a 5200 request. Right? So if you think about it, if you have a well-functioning board and you say, hey, what's the most current version of the CC&Rs? Response, we'll email it to you, or we'll send you a copy. Or, hey, what happened at the last meeting? Could you send me the minutes? Hey, no problem. We'll send those over to you. Yeah. This typically comes into play when they reject or ignore those requests. So that's really where you sort of ratchet up the demand. Understood. So just to frame it a little bit better. Yeah. So next category, contracts and vendor information. This is where you really get into the agreements, the contractual obligations of the community with third parties. Yeah. So we've said this before, a management company is a third-party vendor. Yeah. Even though it gets convoluted quite frequently. Yeah. A lot of people talk about how bad their management company is. They think it's one and the same. Yeah. But the blowback, it really comes back to the board. Yeah. No. And under agency theory, if you have a management company that's engaged in misconduct, that's going to flow back to the board as if the board is doing it. Yeah. Right. And that's how that works legally. But in terms of a management company, from the law's perspective, that's a third-party vendor. And how are those relationships established? They're established through contract, typically in writing. Well, it should be in writing, at least. And so this allows a homeowner to go after that contract, request the contract, and have a copy of it. Got it. So that's a very powerful one. The other one we have listed, operational and annual disclosures. This is annual budget, reserve disclosures, assessment collection policies. Sometimes this becomes very relevant to, the financial health of the community, right? If you have a board that's not revealing financials or what their budget is, or they're very cagey about that, that's typically a red flag. Yeah. And if they dig in, they entrench and they say, hey, we're not disclosing anything about the financials, 5200 becomes a very powerful way to get that information. Okay. We also listed membership and ownership records. This is a membership list, name, addresses. And so membership, we're talking about homeowners or condo owners. Yeah. Now, members of the association. Now, when we go through this, some of this has caveats, right? It's, for example, there's certain privacy requirements with this one. Yeah. And some of those things come into play, but generally speaking, a list of who the members are, the addresses, it tends to be relatively fair game.
But there might be something sensitive like a social security number that needs to be redacted.
And that's where redaction comes in.
Okay.
And so there is this privacy balance at the end of the day that you will see come into play.
Yeah.
So, for example, I can think of it on a vendor agreement. This would be kind of atypical, but let's say a social security was on a vendor agreement.
Oh, okay.
I wouldn't be surprised if that was redacted.
But they still need to provide it to you, but just with the proper privacy protections.
Yeah, because then they could have trouble on the other side of that, right?
Sure. Yeah.
So that's sort of the big picture of what homeowners are entitled to.
Yeah.
The next question, which is immediate, is like, well, what can't we have?
Yeah, and there are some things there that people think they're. I mean, obviously, the majority of this stuff is wow, they're entitled to quite a bit, but there are some things that are off limits. Yeah.
Right. So yeah, let's get into that. Kind of came up with a nice list here too. I actually really like this list because it's fairly broad.
Yeah.
So this is one that I see quite frequently. Attorney-client communications.
Mm.
And what that means is, the board often has corporate counsel.
Yeah.
And the corporate counsel, their client is the board as a legal entity, right? So if you think of it that way, legal entity, HOA, and the attorney. And so typically communications between the two will be privileged. There's an attorney-client privilege that attaches to it.
Yeah.
And so that is often considered off limits. Now, there are exceptions, of course, but when we look at how the privilege attaches, this tends to be sort of a world where it's very hard to penetrate.
Yeah.
Because they can allege, well, we have a privilege on these documents.
Sure.
And, they're typically right about that.
Yeah. So the communication between the attorney and the sitting board members.
Well, it could be anything from communications, emails, legal opinions.
Like strategy.
Yeah. Risk analysis.
Yeah.
Stuff that was specifically prepared in the context of the attorney-client relationship.
Understood.
So often off limits.
Yeah.
Okay. Personnel records. That's another one.
Okay.
Sometimes that's confidential. So those sort of tie into sort of the HR world of what HOAs do.
So like any wage information or HR complaints or anything like that has to do with an employee.
Typically,
or someone that works. Yeah.
Generally, yeah.
Yeah.
And then that sort of goes over to information about homeowners that's considered private. Sort of confidential information.
Like bank accounts,
Social security numbers.
Yeah.
Right.
Yeah.
Often off limits.
What about like violation letters to those homeowners?
That depends.
Yeah.
Sometimes yes, sometimes no. But sort of these ongoing investigations or enforcements that may be off limits.
Okay.
So if there's an internal investigation, often maybe there's counsel involved in that.
Yeah.
That might be considered off limits.
Understood.
Now you have to remember too, when we talk about off limits, and anytime lawyers talk, it's always with a caveat. It depends.
We have I think some mugs around here.
We do have some mugs.
It's allegedly.
Allegedly.
And it depends actually.
It depends though. I mean, there are exceptions to these things.
Yeah.
You are somewhat operating in a gray area to some extent.
Yeah.
But I think this is good as a general rule of thumb. And then if there's ever a real question or there's a real need to get this information, that's probably where you consult with a lawyer.
Yeah.
And have the lawyer look at it because there's other factors that might go into the analysis. So
interesting.
It depends on some of these. So next is executive session materials. These would be minutes or notes regarding litigation strategy, third-party contracts under negotiation, personnel issues, or member discipline.
Okay.
Now, some of that really falls into that black box, if you will, where they don't necessarily want this information being released.
Can I ask just a general scenario?
Yeah.
Okay. Selective enforcement.
Okay.
That seems to be, that's a very common tale, especially that we see, homeowners call us about. Got a political sign up or whatever the case may be. And so does Jan down the street.
Okay.
And you get the violation notice. And do you have the right to say, great, show me Jan's violation notice from the HOA?
We often request that under 5200.
Okay.
Other violations. That's different than ongoing investigations.
Okay.
So you wouldn't say, hey, show me everyone who's currently being investigated, or there's some sort of file on, sort of what's been happening in the neighborhood. It's a little bit different than an actual violation notice going out, right?
Yeah.
So, and the other thing too, you got to remember, this is all outside of the context of litigation.
Yes.
So this is, if you will, pre-litigation, because there's no courts involved, right?
This is just the typical day-to-day without, like, hopefully legal intervention at
right.
That point.
And so your request is under, like I said, 5200, which is different than the Discovery Act.
Okay.
Discovery Act comes into play during litigation. And so that might open up some of the information you're entitled to, which I don't want to go too much into litigation and how that works.
Yeah.
But
if you're at that point, you already have a lawyer involved.
Right. And so this, if you look at it, this is really sort of the precursor to, and this is essentially a discovery tool because you're still getting information.
Yeah.
And just to put it into context, discovery is the way in which litigants exchange information. It's the procedures, it's what they're entitled to prove up their case or their defense.
Yeah.
And so this exists obviously outside of discovery, which can be a very powerful tool unto itself in terms of getting information early on, likely because there's some sort of dispute brewing or there's some issue with the HOA.
Got it. Yeah.
All right. The next one, medical or disability related documentation. That's a little bit self-evident, right? I mean, there's some, HIPAA regulations, or there's certain, medical records you're probably not going to get.
Yeah.
And then lastly, any record not maintained in the ordinary course of business. Now, what does that mean?
Yeah.
You ask for some sort of report or some sort of aggregate of information that the association reasonably just doesn't have.
Oh, yeah. Okay, that makes sense. Or you're requesting something that doesn't exist.
Period.
Like, I want a soil report on the field to prove that it has X, Y, and Z. Yeah.
And they say, well, we don't do that normally. We don't normally take soil samples.
Okay.
We've never done it. And so you can't necessarily go and say, hey, I need you to do this now.
Makes sense. Yeah.
So those are the sort of off limits. And I think the next big thing you need to talk about, though, is how do you actually request? How does the request take place?
Yep.
So under 5200, now I wouldn't say that there's any sort of magic language, but I would reference the statute. This demand is made under, Civil Code 5200, and I'm hereby requesting the following. And then you just list out what you're seeking.
Yeah. So often we tell the homeowners, number one, be clinical, and if you can, elevate your vocabulary, because it shows that you mean business and you know what you're talking about, and they're probably going to take you more seriously if you're calling out civil code this, I request this under this, and you keep it clinical. It's usually going to get flagged, or hopefully someone's going to read it and say, oh, okay, we should take this seriously.
Well, it's more powerful.
Yeah.
And so, how do you transmit? How do you send?
Yeah.
I would recommend both email and certified. And there's different ways of doing this, but sending it to the management company and the board. If you happen to know who the representative for the HOA is, maybe it's a lawyer, maybe send it that way.
Yeah.
But ultimately, you send it to the management company and the board via both certified and email. That tends to be sufficient. Yeah. And what you want to do is, again, identify the category. And then lastly, you're going to say, well, how do you want this information back?
Yeah.
Is it through inspection? Do you want to go down to the clubhouse and actually just visually look at it? Do you want hard copies?
Yeah.
Or is electronic sufficient?
Yeah.
So make that in the request.
Make that in the request itself.
And obviously, if it's very voluminous and it's just a ton, you may just want to start with an inspection. Yeah. Go down there. Go to the clubhouse. Take a look.
Can they put it in front of you and you grab your phone out and click, click, click in front of it?
That tends to be okay because that's a version of a copy, right? Yeah. You're entitled to the information. Yeah. And you would save with copying expenses if you did it that way.
Which we'll get into in a minute.
Yes.
Okay.
All right. Next fun one is you send it out, turnaround time.
Yeah.
Okay. Typical, most records are 10 days. Like your average, if you're asking for the most current iteration of the CC&Rs, 10 days. Stuff that's just kept in the normal course of business that's readily available. Yeah. There's sort of a reasonableness standard on this as well. Yeah. And, I think the law understands that some HOAs, they probably have a storage facility where they keep like really old records and someone has to go out there maybe and go through them. Right? Yeah. So there's sort of that balance. But stuff that you would assume is readily available,
Yeah.
you're looking at a 10-day turnaround time. For older records, it's typically 2 years. You're looking at a 30-day turnaround time.
Okay. So any records that are older than that usually
Yeah.
30 days.
Yeah. And then, minutes, I don't believe I should say that. It's 30 days after the meeting.
Okay.
So that's a reasonable, again, reasonableness, right?
Yeah.
You're always looking at reasonableness.
Yeah.
So that's generally the timeline. Now, what could happen is you can make the request and then Tom from the management company says, hey, I need an extra 5 days.
Yeah.
Well, is it reasonable or is it a delay tactic? That's kind of case by case.
Sure. I mean, we go back to so often document everything.
Yeah.
Right? Just say, just put in your notes, I requested it, keep this on file, because to the extent they don't and they just start giving you the runaround, you're showing the pattern
Right.
of the runaround.
Well said.
Yeah.
100%.
Yeah.
So now the fun part of this is what are they doing? What is the penalty for noncompliance?
Let's first talk about
Cost.
cost.
Yes.
Yeah, because I see so many people get so aggrieved by, they say, oh, well, it actually does in some certain circumstances cost money for some of the stuff.
So I think the rule of thumb on this is the way to look at it. What is the actual reasonable cost to get you what you need?
Yeah.
And what does that mean? Well, you need 50 pages printed. What's a reasonable price of that?
Yeah.
Now, if they're charging you $100 a page, that's a problem, right? But you maybe cross-reference it with like a Kinko's or a FedEx store and sort of see what is the going rate for copying.
Yeah.
And I think it's very obvious if it's egregious.
Yeah. Yeah.
Right.
They're trying to dissuade you.
Right.
From,
and if they do, let's say they do, and they say, well, you wanted 7 pages, you wanted the current version of the CC&Rs, we're happy to comply, but that's going to cost you $1,000. Funny, but I've seen it before. I have. Yeah. They actually try to block these 5,200 requests with absorbent fees.
Hmm.
And so what happens is, you take that and then you eventually use that against them as another example of bad faith. Right. I mean, that's sort of how you take that and use that to your benefit.
Sure.
But, again, I think it's cross-referencing what market is to produce. Is it reasonable? That's the question.
What about cost of like sending it or anything like that? Like, so we have copying costs.
Let's say they mail it to you. That's reasonable.
Yeah.
Or you can go down and pick it up. Typically what happens is you go down and pick it up at the management company.
Yeah.
They say, hey, we have the bylaws, we have the minutes that you requested and the financials. We made copies and it's their printing costs.
Yeah. Anytime if that something needs to be redacted, is that ever a case where you have to pay for that as well? Like, let's just say
I haven't seen that.
Okay.
But again, you never know what you're going to see come down the pipeline. But again, I think you always got to back it into a reasonableness standard.
Okay. That makes sense.
Yeah.
Now the fun one.
Okay. So this gets interesting because it's really two things. One, it is an actual $500 penalty per violation.
So
you fire off a demand. Let's say you're looking for the minutes and you're looking for financials.
yeah.
Maybe let's say four document types. And they bar you on all 4. They either shut you down, they ignore you.
Yeah.
It becomes a $500 penalty per violation.
Interesting.
Now, where it gets more interesting, though, is there's an attorney's fees provision attached to this as well. So this actually becomes its own violation or cause of action in a lawsuit if it goes that far. And normally how you see it play out, though, is the homeowner will have maybe a breach of contract or a selective enforcement or these other legal issues against the board, right?
Yeah.
And in the process of this dispute, they send the 5,200 request, which is ignored or denied. They then take it to mediation. So under Davis Stirling, before you file your suit, you typically pursue mediation first to try to get it settled.
Yes.
Right? You make the demand, you attend the mediation, you put forth your demands to the association, and you say, hey, you caused X amount of water damage or property damage to my property. I've had to spend X amount of money on attorneys, which is BS. I should have never had to hire an attorney in the first place. So I want reimbursement for that. I want reimbursement for the property damage. Oh, and by the way, you screwed up and you didn't respond to my demand, my 5,200 request. So I want penalties for that.
Yeah.
They get it to the board. The mediator says, yeah, you're entitled to this. If you file suit, you'll prevail. Let me go talk to the board. The mediator goes to the other side, and their attorney says, go kick rocks. We're not going to settle. Okay. Then you file your lawsuit. So as part of your damages, what you're going to be seeking, in addition to all the actual damages, you'll be seeking recourse or reimbursement under $5,200 in that lawsuit.
Oh, interesting.
So it's sort of
it's not just the cost of getting the evidence, if you will. It's if there's the actual violation associated with
it rolls over, so it can go all the way into the actual lawsuit, which actually makes it a very spicy, sort of way to enforce.
Yeah.
And it also, I think rightfully so, there's a downside if the association elects not to comply with your demand. And at the end of the day, that's a good thing because you want to incentivize them to be reasonable.
Yeah.
And again, we're going back to transparency. If you have nothing to hide, just be transparent.
Yeah.
Turn over the CC&Rs, turn over the budgets, turn over the vendor agreements. That's a well-functioning HOA. They shouldn't be hiding stuff. And 5,200 really came in to ensure the homeowner had the right to go after certain documents, to allow for that transparency.
Yeah, it should be what do you got? What do you have to hide? Like,
but if you look at it, the bad HOAs have a lot to hide, right? I mean, that they do. They don't want to show the financials. They don't want to show the vendor agreements potentially. Why?
Because there might be some.
Well, they might be paying way above market value, and the vendor who they've hired at 4 times market rate happens to be cousin Vinny, right? The board's cousin.
Sure. And
the board is getting a kickback from it. So there's so many things that could be exposed through these documents. And so again, we're talking about bad HOAs.
Yeah.
We're not talking about good HOAs. So a bad HOA, they do have a lot to hide.
I know. It just seems so egregious. You know what I mean?
It is. But again, and I think this goes to the premise of everything that we're doing. It's egregious, but if no one's calling them on it, it keeps going. It keeps perpetuating.
I think that's the really good point. Is we say over and over on this show, the homeowners actually have a tremendous amount of rights. It's great. If you don't enforce it, then what do you actually have?
It doesn't matter.
Yeah.
And so this is how these egregious things snowball.
Yeah.
And maybe it starts small, but it eventually culminates into these massive self-dealing moments or other egregious acts.
Yeah. Well, let's give them the quick takeaway, the recap, the quick takeaway here. So,
all right. Yes.
You want to rapid fire these?
All right. Let's do it. I'm going to put my glasses on. There we go.
Oh, there you go.
Yeah. I've been reading small text for too long. All right. Yeah. How do you want to run the takeaways?
Well, let's just go through it. Homeowners have a lot of, listen, let's start here. Homeowners have a lot of rights when it comes to transparency. They can request a lot of different documents.
Yeah. So I think at the end of the day, it boils down to this. The homeowner has rights under 5,200 and it forces an HOA to be transparent. And those rights or those documents that they're entitled to, they've hit certain categories.
Yeah.
Right. You have financials, you have governing documents, you have board governance. Right.
Yeah.
And so the homeowner has the absolute right to these under the code. Right.
Yeah.
And in order to get those, you got to do it correct procedurally.
Yeah.
So you make your demand in writing. I would do both certified and email. And the board has a certain amount of time to respond.
Yeah.
And again, that response time is a reasonableness standard. What is reasonable? Right.
Yeah.
And there's different sort of classifications of that. And then to the extent that they don't respond and they stonewall you or sandbag you or however you want to frame it, there's penalties to that.
Yeah.
And those penalties can be very severe depending on how broad your request was.
Yeah.
So if you ask for 50 categories, 50 times 500, you're talking about serious money.
Yeah. And I think just to put a bow, not everything that you want, it's a possibility that you request something that
fair enough.
That you do not have legal standing to have.
Correct. There's some things are off limit.
Yeah.
But those things that are off limit sort of make intuitive sense.
For sure.
Right?
Yeah.
So yeah, if you want the soil sample that they've never taken, you're probably not going to get that.
Or you want the social security number of the clerk.
Yes. Yeah, you're not going to get that, or medical records and whatnot. So I think 5,200 is a nice balance. I think it's fairly reasonable, and I would classify 5,200 as a homeowner empowerment tool, and it's very powerful when properly leveraged.
Yeah.
It just has to be leveraged correctly, and people have to know about it.
Yeah. And
those in California, at least.
Yeah, and we've had Jeff on, managing partner at the Florida office, and we've talked about document requests.
Right.
And it seems like this is a very, I mean, we can only talk through the guys, you specifically, with California,
Right.
but there are so much of this is repeatable.
Right.
Like requesting it in writing and certified mail. Certified mail was the Florida one.
Right.
But I recall, not a lawyer, obviously.
Yeah.
but so much of this can be repeated in just elevating know what the rules are, know what the law is, request it. So much of it, I'm sure, is transferable.
And
to,
you know what's interesting
states.
too? We'll get clients who have maybe attempted a 5,200 request.
Yeah.
And, for whatever reason, they got some of the documents, but not all of the documents. And even if you are going to use a lawyer, by running that 5,200 play, it's going to put your lawyer in a better position. God forbid you need a lawyer.
Yeah.
But it's already sort of moved the ball a little bit forward.
Yeah.
So it's not a bad move.
Yeah.
And, best case is you make a 5,200 request. Let's say you find a smoking gun, right?
Yeah.
That becomes very powerful in your own self-advocacy.
Yeah.
So anyways, I would, strongly recommend, I encourage homeowners to look into it. If they have an HOA that's not being transparent, this is a very powerful tool.
Yeah.
So,
I like it.
Cool. All right. Well, thank you guys for watching. I hope you found that very useful. And again, we are watching Reddit. We're looking at it. And we love the comments. We love the recommendations. Whatever you guys feel is very mission critical, that's going to move the needle, we're happy to discuss it and keep empowering you guys.
Yeah, we got more to come too.
Yeah.
I mean, I hope that if anyone took something from our Reddit, is that we are listening. Like the people asked for it. Hopefully this satisfies, and we will continue to look there. We'll continue to put up awesome content, and we have other stuff even within the next couple weeks that we're going to continue to put out there.
Yep.
Hopefully that's going to continue to empower more homeowners.
Well said, Marty. All right, guys, thank you. Subscribe, like, and leave comments.